Hello and welcome everyone to Immigration and Jobs Talk Show. I'm Napasa Pradhan and it's really good to have all of you join us today. Before we start off with today's session, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, once again, welcome to Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and today we are diving into this very crucial question. Will the latest USCIS changes make EB-1 harder to get? And if you're a product manager, a software engineer, or anyone, working in a high level field, this conversation is going to definitely benefit you, so you can't afford to miss. Thank you for joining us. These new USCIS updates might change the way extraordinary talent is recognized, and we want to make sure you stay ahead. So, thank you so much. Joining us in today's discussion is the brilliant attorney Prashanthi Reddy, an expert in immigration law who has been guiding us every Wednesday. So, thank you so much, Prashanthi, for joining us in today's discussion. It's really good to have you back.
Thanks, Nipasa. It's good to be back.
Same here. So, folks out there, yes, EB-1 journeys today is what we are going to discuss about, especially on the new updates. And Prashanti, thank you so much for being here with us, and definitely also a very warm welcome to folks out there who have tuned in. Whether you are watching us on YouTube, LinkedIn, or Facebook, thank you so much for joining us. And let me tell you that this is also, conversational, and you can also participate in this. So all you have to do is just comment whatever questions you have, especially on this topic, and we'll be very glad to take them up in a short while. So I think, Prashanti, let's not wait any longer. And if you could just take us through the key highlights, of these USCIS updates and what they mean for applicants, especially the EB-1 applicants out there.
Sure. So, recently, this month, USCIS has put in a set of key updates to the um, how to evaluate whether a person is an EB-1A qualified or not. This is second set of updates that USCIS has given. The first was in September, so now they're continuing to update the criteria. It's small changes that they're making, but they're chipping away at it, and they're trying to make clarify things better. Of course, the law cannot be changed, but they're trying to clarify what the law is. And our sense is that they are through the clarification. I mean, we can expect with the clarifications that we'll see a shift in the way they process cases as well. Even though the actual law hasn't changed, how they process them might change, because in EB-1 there's a lot of scope for interpretation, right? The officer interprets a lot of things. It's not okay, x plus y equals z or something like that. It's they look at a lot of things subjectively, even though they try to be objective, and there's some certain key criteria that they have to follow. There's a lot of room for interpretation. So whenever they give us these updates, it means that there is some small change in the way that they will be looking at your cases and the way that they'll be processing them. So the latest update in October for EB-1 is they've specifically said that they're going to be considering team awards. So they will now consider an individual's participation in a team under this criteria. This is for lesser nationally or internationally recognized prizes or awards of excellence. That's one of their criteria. And under that, they said that they will include any award that is given to the person because they're part of a team. Even if that person has not won a personal award, if their team has won an award, that will be considered also. So USCIS will consider then their contribution to the team in the area that they have been recognized. So this will give some increased flexibility, particularly for individuals in fields where team efforts often play a central role in success. So there are a lot of research that is being done as a team, right? Because one person cannot do the research. It's usually done by multiple people, because different people are doing different aspects of the research, and then the entire the whole thing comes up as one paper. So often you see that a paper is written by many people. It's not just written by one person. And if you look at even the bigger awards like the Nobel Prize, etc., they're, in physics and science, it's given to a team, to more than one person at least, because there's some joint research being done. So this kind of recognizes the reality, and increases flexibility, and um, increases the scope of getting awards under this category of national or internationally recognized prizes. Of course, if you get the Nobel Prize, then no criteria is required. Just that by itself, that one criteria is enough. So, but this is for people who, get lower prizes, lesser but more still important prizes. Second criteria is inclusion of past memberships. USCIS will consider applicants' past as well as present memberships um, uh, in looking at whether they have outstanding achievement or not. Just going back quickly to the team awards, previously USCIS did not look at team awards, they would look at individual awards, and some officers would look at team awards. So this kind of clarifies things that they will for sure now look at team awards. And, they're making it, as I said, EB-1 is very subjective, and it's often difficult to figure out by looking at a case whether the case will get approved or not, because most cases are borderline. These criteria, these additional evidentiary criteria that USCIS has constantly been giving us, does help to narrow that down a little bit. So the next point, as I was saying, is the inclusion of past memberships. Previously, USCIS would not consider past membership, they would only consider present membership. So what is this? This is one of the criteria again, membership in associations that demand outstanding achievement. So not just any membership, but if you're part of a group, that you can only become a member because you qualify based on certain criteria that everyone cannot qualify. So you have to be in the top of your particular um, achievement to be able to join that membership. If that is the case, then membership in those associations is one of the criteria. So previously, USCIS would only look at present memberships. That means that you had to be presently a member in that particular association that requires high achievement. Now the shift helps applicants who were previously affiliated with prestigious, professional groups or associations, but now they may not be for whatever reason. So this adding this past memberships broadens the scope for recognition of such people's, expertise and accomplishments. So inclusion of past memberships. That's the second one. The third criteria is relaxed published material criteria. So USCIS previously used to have language that required that the material that is published about you must explicitly highlight both the value of your work as well as your contribution in the field. So if it was generally published material about what a great scientist you are, but didn't actually talk about why you're a great scientist or that particular field that you've worked in that has made you a great scientist, then that published material was not allowed. Now they're allowing all published material that discusses you as an individual, without, even if it doesn't specifically add or demonstrate how your work is significant. So there could be, as I said, an article which just says that, brilliant scientist blah, 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 but doesn't have too much information as to why you're a brilliant scientist, that can still be included as the published material under the published material criteria. So this has again increased the scope of evidence that can be given without, including narrow evidentiary requirements. So that's really helpful. So more evidence can be, more wholesome evidence can be included, just, showing that, that particular person is, extraordinary in their field. Last but not the least, the fourth criteria is clarifications on exhibitions and showcases. So previously, only artistic exhibitions or showcases were considered as part of evidence to show extraordinary ability. So, I mean, because traditionally it's artists, it's painters, photographers who had exhibitions and would showcase their art in that way. But more and more, there are other areas where, work is showcased or exhibited. That can happen in the technical area as well. So this expands opportunities for non-artistic fields where you can still show that by exhibiting publicly your work, you can still show that that is one of the criteria to show that you have extraordinary ability, especially if the exhibition, is of a high quality or where other people equally accomplished exhibited their work. And if it shows that, because of exhibiting in that particular area, in that particular exhibition, you are able to demonstrate extraordinary skill, recognition, or reputation. So again, exhibition and showcases for all kinds of work, not just arts. So that is again an additional criteria that they've included. Nipasa, should I go on to how this actually changes the way B1s are done?
Yes, we could. If you could give a few tips, and if these new changes has changed any of the previous processes, you can highlight that as well.
Sounds good. So, impact of this updated guidance, is there any impact or not? Um, I mean, there is obviously some impact. And just to go back to last month in September, I mean, last year, sorry, September of 2023, there was updates to the USCIS policy. And so, it seems like they're updating it in bits and pieces. In September, when they updated, they basically gave more flexibility to the ways that you could demonstrate extraordinary ability. So they allowed you to submit evidence, which, usually they don't accept. So they allowed more types of evidence, and if a particular evidence that had to be given based on their criteria didn't make sense for your particular area of expertise, then they allowed you to give comparable evidence, right? So you didn't have to stick to the evidence that they say in the rules has to be given to show extraordinary ability. So there was more flexibility in the kinds of evidence that you could give. That's what happened in the September 2023 update. And now with the latest update that we have in October of 2024, just breaking it down, for example, the team membership provision is again encouraging, is very encouraging because, earlier adjudications were inconsistent on this issue. And sometimes they would approve cases where you had, an award as a team, and sometimes they would deny them. So even though this change may seem minor, if you look at it on the whole, we see that it's a positive outcome. On the whole for EB-1 categories, it seems that USCIS has become more flexible, and they're processing cases in a more flexible and relaxed light. Even though there's high standards still apply, and all the standards still apply, they're giving us some ways to kind of some flexibility with reference to evidentiary requirements. So team membership is one of them, and it's good that they have that in place. Also, with reference to team membership, as I mentioned earlier, Nobel prizes in the sciences are awarded to team members. So by recognizing that winning such an award, um, it shows extraordinary ability. USCIS is basically aligning its rules to long-standing, long-established standards in the industry, in the area of business or science or arts, etc. So they're aligning it more to real world, which really helps. While September guidance describes, as I was saying, September guidance really helped in 2023 because it described more evidentiary criteria that can be given, not just the usual evidentiary standards. And therefore, it actually made it more possible for people in private industry to apply for EB-1. So EB-1 was mostly known for, scientists and, people in the arts, nonprofits, not so much for people in business and who are in private industry. So by making these changes in September and also making the changes in October, what they have done is, um, you know, they've made it more logical and common sense, of course, but they're also opening it up to more areas where you can show that you're extraordinary. So more private industry as opposed to just the arts and the more and the sciences, the more traditional extraordinary ability, as we would say, would be the sciences and arts and singing, etc. But so they've opened it up more to people in business, maybe businessmen over academia, and people in private industry as well. So overall, I think that's the changes that they're trying to make, opening it up to more areas. Nipasa, over to you.
It's Thank you so much for guiding us and for navigating us through all these new guidance the USCIS has brought up for EB-1 category. Prashanti, it was really great that you covered that for us and for highlighting all the changes. I would just like to say hi to David and Faris. Thank you so much for participating and for your questions. And I think, Prashanti, if you don't mind, we should take up David's question for now.
Sure.
Uh, David is saying, I am currently an assistant professor and head of my department at a top ranked university. If I want to apply for an EB-1 visa, how long does the process typically take and what are the expected costs for processing?
Well, the processing, it depends on, well, the processing time is the processing time for an I-140 and, of course, the processing time for a 485. Those are the two steps that you have to undergo, and it's possible if your visa number is available under EB-1, depending on your country of nationality, country of birth. Um, you could possibly file both cases concurrently, the I-140 and 485. I-140, there is premium processing available, and you have to keep checking because sometimes they remove premium processing for I-140 and then for EB-1, I-140, and sometimes they bring it back. But if the premium processing is available, then 30 days is usually how long they take to process these kind of cases. Um, and if it's not premium processing, then it takes 4 to 6 months for them to process it usually. And for a 485, if your visa numbers are available, then it takes typically 12 months to 14 to 12 to 18 months, I would say a year to a year and a half for them to process or adjudicate your 485 application. The cost really depends. The cost is basically what you have is the attorney cost, and every attorney charges differently. It could be from 5,000, 3,000, 5,000, 10,000, whatever they charge. And then, of course, there's a USCIS fee, which you can go and look up on Google with reference to 485. There is a particular fee. I believe it's 1220.
Mhm.
I-140 is $700 odd. So don't quote me on the exact number, but that's the approximate numbers on the fee. And of course, the
Mhm.
attorney fee can vary.
There you go, David. You have the timeline for the whole processing and also the expected cost. Thank you for your question and thank you for participating. Thank you, Prashanthi. We have Rag. Hi, Rag. Thank you for joining us. He's asking any changes to the EB-1C?
So EB-1C is the multinational executives managers. That's EB-1C. That's not extraordinary ability. Completely different category. And no, they haven't said, they have not made any changes to EB-1C recently.
Hmm.
This only applies to EB-1A,
Okay.
extraordinary
So, Rag,
ability, basically.
yeah, no changes as yet for EB-1C. Thank you for your question. Thank you, Prashanthi.
You're
Now let's
welcome.
go to Faris's question. This is on YouTube. Faris is asking, could you explain how working through backlog cases in the visa lottery process can help support the investigation of selected applicants? Additionally, what resources or assistance are available if I need further guidance on this process?
Let's read it again. Read the question again.
Could you explain how working through backlog cases in the visa lottery process can help support the investigation of selected applicants?
I don't quite understand the question. Can you explain how working through backlog cases
Visa
can
lottery.
help support the investigation of selected applicants? Maybe you can rephrase your question. Sorry, I didn't quite get what you're saying. But if you're asking me, does working on backlog cases um, help?
Visa
Please
lottery
rephrase your
process.
question. Yeah.
Yes. Yes, Faris, you really need to rephrase the question. Tell us about it. Thank you for your question. All right, Prashanthi. Well, I have some more questions we have on our Facebook groups and our YouTube as well. So let me just share some of these questions with you. All right, so there we go. Let's start off with this one. This was a few years back, a few weeks back, sorry, on our YouTube. This is from Arjun. Um, One question: how about the applicant had suitable criteria for EB-1A 15 years ago, but now he is into different job sector and current situation is not suitable for the criterias? Can this still be a valid case for EB-1A petition?
So USCIS clearly says, for extraordinary ability as to when they talk about who's eligible, it has to be one of the criteria is that it has to be that the person is continuing to work in the area of expertise.
Mhm.
So therefore, if a beneficiary is not working presently in that particular area of expertise, at least they should be working in a related area of expertise. If they're not working at all, then that's a problem. So while they're willing to look at it with more flexibility, for example, what the example that USCIS gives is if there is a star athlete and the person is no longer an athlete because maybe they've become older, but they're
Mhm.
still working the area because they are coaching and now they're a star coach. So they are still working within the area of expertise as per USCIS, so they're giving that flexibility. But if you're not working at all, in that area and you're working in a completely different area and you're not extraordinary anymore in that particular area where you're working, then it's not, then you won't qualify for EB-1A.
Okay. Okay, thank you so much for taking that up for Arjun. And Arjun, we've got your question answered. If you have more questions, you can keep commenting. And now, Prashanthi, I have another question, and let's go to this one. This was from our groups, but it was anonymous. How long it took from RFE response sent to approval for PP? Response to USCIS's request for evidence was received to decisioned, approve or rejected timeline.
But what kind of case? How long does it take? What is the question?
How long it took from RFE response sent to approval for PP?
What is BP?
PP, even I don't get it.
Oh, premium processing. Oh, PP. Okay, sorry.
Premium
Because
processing. Okay.
I can't read the thing, so I'm like, okay,
Let me
got it.
try
PP.
to just zoom in a little. Can you see
Okay,
this?
now I did.
Yes.
I got it. I got it. I got it. Okay.
Okay.
So how long does it take from RFE response sent to approval? Premium processing, RFE, how long does it take is the question basically.
Mm-hmm.
Um, so premium, if you're doing premium processing, usually they will respond within 30 days. That's what we've seen usually, but even though the premium processing clock stops, because they promise to respond within that particular period of time, but the response could be when you pay premium processing, could be an approval or it could
Mm-hmm.
be a request for further, it could be um, an RFE, yes, a request for further evidence. So after that, the premium processing clock stops once you get the RFE. But generally, I've noticed that in premium processing cases, they do respond to RFEs in about 30 days or so.
Okay. Thank you. Thank you for taking that up, Prashanthi. Now let's move on to this next question. This is from Manikandan Nadar. PERM applied on June 9th, 2023. It's been 487 days, 15 months, 29 days only, and this was 7th of October, and still waiting. So, what do you suggest?
Um, so yeah, if the perm was applied, perm usually shouldn't take more than 8 months, but it could take a year and a half if if the perm was audited. But shouldn't take more than that at any given point of time. Unfortunately, with perm cases, you can't really follow up with anyone.
Okay.
There is, um, yeah, so it is taking, I don't know whether there's an audit in your case or not, but maybe go to the flag website, ask your employer or attorney to go to the flag website and check if there's any further updates and perhaps follow up there on the on online on the flag website. Um, but yes, if there was an audit, then 15 months I think is an okay time period. But if there isn't, then that's unusual.
Okay. Thank you so much for taking that up. And Manikandan, we've got your question answered. Let's hope for the best. Next, I have this question. This is from Aditya. I'm currently on an H-1B visa and my perm was filed in September 2023. My H-1B is set to max out in February 2025. I have been affected by recent layoffs and I'm considering switching my status to H-4 and I have a few questions. If I switch to H-4, will my original H-1B still remain valid? And can I still file my I-140 if my perm is approved while I'm on H-4? Would you like to take them one by one,
Yeah,
or I'll just
yeah.
read through?
So first question, if I switch to H4, will my original H1B still remain valid? I mean, there's nothing to remain valid because you're not on a H1, you're now on a H4. And if
Hmm.
you want to then switch to a H1, you'll have to file a change of status again. Can I still file my I-140 if my perm is approved while I am on H4? Um, yes, you can file an I-140 while you're on H1. There's no intent issue when you're on a H4. So you can have a dual intent and file a green card as well and file an I-140 as long as well, the main issue with the I-140 is ability to pay. But if you are continuing to work for the employer on a H4 EAD, then you might still your employer will still have the ability to pay the prevailing wage because you're on their payroll. If you're
Hmm.
not working, then that issue might come up because then they'll have to show that they have the ability to pay your prevailing wage, the entire prevailing wage, because they're not paying you anything right now. And that
Yes.
they would be able to show that through their tax return, through their current assets, or their profits, which have to be equivalent to or more than the prevailing wage. So it's possible, but it might be difficult in some circumstances. If I get a new job, can I switch back to my previous H1 and continue from where I left off? Yes, you can file for a transfer at any point of time, or a change of status, sorry, from a H4 to a H1. So yes, you can move back to a H1. And then the last one, is it best to switch to H4 at the moment, or do I have any other options?
Options.
Well, if your H1 is maxing out, and if your I-140 is not yet approved, then you would have to switch to a H4 or some other status like a B2 or an F1. I think a H4 is a good status to go on to when compared to a B2 or a F1,
Okay.
unless you want to go back to school or something. So that really depends on what your situation is.
Yes.
Um, and you have to remember, once you go to a H4, you may not immediately be able to work because your H4 EAD has to be approved, and you have to qualify for a H4 EAD. So
Okay. Thank you so much, Prashanti, for taking that up. And Aditya, we've got four of your questions answered. So hopefully that works. And if you still have more questions, you can keep commenting. And thank you again, Prashanti. Now let's move on to this next question. This is an anonymous member asking, I submitted my EB-1 I-140 a couple of months back, which is still in processing. I have a previous EB-2 NIW priority date of December 2021. Since EB-1 current date is 2022, my law firm suggests that I apply for premium processing for my EB-1 application. Just wanted to know if there are any cons to this process. Thanks.
I don't see any issues with premium processing. A lot of people seem to think that if you submit in premium processing, then it's more likely that your case will get denied, because I don't know, for whatever whatever reason, because they or more likely that your case will get an RFE because they don't want to adhere to the processing time periods. EB1 anyway, the chances of getting an RFE are pretty high for anybody. So I don't see any disadvantage in filing for premium processing. And of course, that there is a advantage with reference to time. So go for it.
Only pros, no cons. So thank you so much, Prashanti, for highlighting that. And quickly, I'll just say hi, Sakshi. Hi, Vasista. Hi, Neha. And thank you for your questions. Thank you, Jada, for joining us, and also Bikram Rao. I will definitely. Bikram is asking, can I ask a question? You can ask a question. Please feel free to drop them in the comments and we will take them up. Quickly, just finishing a few more questions from our Facebook groups, and we are going to jump into your questions. So please don't go anywhere. Stick with us, all right? Prashanti, my next is this one from another anonymous participant asking, I can provide these services. Sorry, not this one. Sorry, this is the one. Anonymous member asking, hello all, hope everyone is safe and sound. This is regarding I-485J. I had my I-140 filed under EB-1, got approved a long time ago, and I-485 is pending with USCIS. I'm getting a good job opportunity in order to change the job. I know that my I-140 is approved for more than 6 months now, and the new company should file I-485J under same role and responsibilities. But this is all my theoretical knowledge. I would like to know from you if you face this situation in reality and if it was a smooth transition. Your inputs will guide me before taking the next step. Thank you.
So it's very common to file under AC-21 to change jobs.
Mhm.
I don't see, in my so many years of practice, I've not seen any issues with filing 485Js or with filing for AC-21. 485J is a more recent introduction, but there was always the option of using AC-21, writing a letter to USCIS and informing them of the change in employment in order to continue with the green card processing. So just quickly, AC-21 allows you, um, if you have a presently a 485 pending, to change jobs or transfer jobs to another employer and transfer your green card processing to another employer, as long as you have an I-140 approved and
Mhm.
your 485 has been pending for 6 months. So it's not Y-140 approved for 6 months, it's 485 pending for 6 months. It's a big difference. So that's one thing that you should know. And the second thing is that as long as the job is same or similar, it doesn't have to be exactly the same. As long as it's similar, I would consider, and this is what I've done in my practice for so many years, any job that's in the IT space, any IT related job like software engineer, uh, I would say similar to systems analyst, which would again be similar to, a data analyst. So even jobs that appear to be dissimilar but are within the IT space, I would say are similar. Some other practitioners do it more cautiously, but I've never had an issue. USCIS, I think, interprets this broadly as to what does similar mean. So as long as it's similar, you're fine. I have not seen any situations arise with reference to AC-21
Mhm.
in so many years of practice. So, it's a pretty safe process to follow.
Okay. Thank you so much, Prashanti, for taking that up.
You're
And
welcome.
now I think we will go on to this next question. This is again another anonymous member. I submitted my EB-1A application to CA Center, but RFE responses address is of Texas. Is that common? So California and
Yes,
Texas.
yes, because they've um, within the service centers, um, decide with USCIS decides basically which service center has more work and which service center has less work, and they continue shuffling cases and shuffling even the RFE responses. So it's common that the RFE might come from one place, but they have instructions explicitly for you to send it to another place, and that Texas is often the place that you send RFE responses to. So yes, absolutely follow carefully what is written in the RFE and send it to that address.
Okay. Thank you so much, Prashanti, for taking that up. And I think we will not keep our audience waiting too long anymore. And let's move to Vasista's question now. This is on YouTube. Vasista, first of all, thank you so much for joining in and also for participating. So his question is, my H-1B case is approved, yet to attend visa interview. I wanted to delay the process and go as late as possible. How much delay I can do to attend the visa interview and after visa is stamped? That's interesting.
Um,
First time I'm
yeah,
encountering
so
this kind.
attending the visa interview, really there is no rule. USCIS doesn't have a rule. Department of State doesn't have a rule that you have to attend the visa interview within a certain time of approval. But I would say don't wait for 10 years, right? Then USCIS, the Department of State is definitely going to question whether, you still have the job or not. So a reasonable period of time would still be a year, maybe a year and a half even. But if you're waiting for that long a period of time, then I would take definitely an updated employment offer letter from the employers stating that the job is still available, and any explanation in writing as to the delay in attending the visa interview. I would have that in writing from the employer.
Mhm.
Maybe change circumstances, job because of job market became unavailable and now is available, blah blah blah, something like that. But only submit it if they ask for it. Otherwise, just have the updated offer letter from your employer so that the consular officer knows that the job is still available. With reference to when you can travel after the visa is stamped, again, the same thing. You can travel at any time during the validity of the visa. If you're going to be waiting for a year, year and a half, again, they might ask you questions at the port of entry. So again, carry the same documentation to explain what was the delay, change circumstances, etc., and you should be fine.
Okay. Thank you, Prashanti, for taking that up. And Vasista, there you go. You have an answer. And if you still have more questions, we are here for a couple of minutes more, so you can keep asking. I think now let's take up this next one from Sakshi. Hi, I'm based in France and recently became a co founder of a US startup. With a PhD in AI, 90 citations, and 4 years as a machine learning engineer, I believe I qualify for both the O1 visa and the EB-1 green card. Can I apply for the green card from France as a co founder? Any advice on the process would be appreciated.
Yes, so if you don't want to come in on a non-immigrant petition first and then apply for a green card, if you are willing to wait, then by all means you can apply for a green card directly. Of course, keep in mind an O1 would be faster. So the path of taking an O1 and then filing an EB1 would be better if you want to come in within a certain period of time, because an O1 is faster. But if you're not in a rush, then definitely by all means you can file for an I-140, consular processing, EB1, and then once your priority date becomes available, or if it's already available, that goes for based on place of birth, not place of nationality or where you're living right now. So if your visa number is available, then what happens is then that the approved immigrant visa is sent to the National Visa Center if you're outside the country, and the National Visa Center makes you then pay the fees online and fill out some DS forms online, which is equivalent to a 485 if you were in the US. It's a green card application, and then once you fill that out, then they will forward it to the closest consulate where you're living. That processes green card cases, and they will then call you for an interview when they have availability. So as you can see, it takes longer to get an EB1 if you're outside the country. Uh, so you should be willing to wait. So that's the only disadvantage of going for a direct EB1 as opposed to going the O1 route and then filing an EB1.
Okay. That's really nice advice, Prashanti. Thank you so much. And Sakshi, all the best. Um, Bikram had asked in LinkedIn, can I ask a question? Bikram, I'm still waiting for your question. So definitely ask your question. We would be very happy to take it up. Now, next, let's go to Neha's question. Neha is asking, this is on YouTube. How can non citizens with extraordinary ability, outstanding professors or researchers, multinational executives, and managers, respectively, fit under the category of EB-1 visa?
Oh my God, this will take 3 sessions, not one session. Because Neha is asking pretty much all the different categories of green cards and how they fit and what is the process. Very, very quickly. I mean, extraordinary ability. I mean, since we're talking about, EB1A, extraordinary ability, let me at least answer that. You have to show that the person has extraordinary ability, and but people who are eligible for that are usually people who have sustained national or international acclaim,
Mhm,
and they continue to work in their area of expertise, and their entry into the US substantially benefits the United States. So this is the eligibility criteria for extraordinary ability. Um, what evidence can be shown to show that they are nationally or internationally acclaimed?
mhm,
Different evidence can be shown. You can show that you have won awards nationally or internationally. They are not. I mean, you have the Nobel Prize, of course. That's the be all and end all. And if you have that, then you don't have to look any further into any of these evidentiary criteria. But if you don't
mhm,
have that, then lesser national or internationally recognized prizes or awards that could be, like, for example, it could be a doctoral dissertation award. It could be a well-known national institution or well-known professional association that's giving the award, um, or certain awards recognizing presentations at nationally or internationally recognized conferences could also be an award that is recognized. So you have to meet three of the following evidentiary criteria. So internationally or nationally recognized awards, memberships in associations. Of course, the memberships in associations has to be um, the the requirement to become a member in those association has to be very difficult. So uh, it's not enough if anyone can become a member. It has to be very selected, the membership. So that's membership. Published material about the person in a professional or major trade publication or media relating to the person's work. Um, and such evidence should include the date, title, author, and if it's not in English, then any, you know, translation. So published material about the person to show that they're extraordinary is the third criteria. Fourth criteria is person's participation either individually or on a panel as a judge to the work of others. So if you've done that, and if it's of a high quality, um, and only if judges are selected, um, the selection criteria is high for such judges. If anyone can be a judge, then of course it won't meet the extraordinary evidentiary standards. So, keep in mind. So, judges, and then the fifth criteria is if you have original scientific, scholarly, artistic, athletic, or business related contributions of major significance in that field. So, if you've contributed, if you have published material, how do you show contributions, published material, letters from people who are, leading in their field, in that particular field, documentation that the person's original work was cited at a level indicating major significance in the field. So, if it's been cited by other people who have written their publications, and that also shows that it's um, a high level, high major significance. So, and original scientific or scholarly, athletic, or business related contributions. It will show that patents or licenses in that field also will show that the person has original athletic, artistic, or scientific contributions.
Mhm.
There are also other criteria. So there are many criteria, and I don't want to go over all of them. So
I know
you have
this
to
is going
meet,
to take
yeah, you have
a
to
lot.
meet one of the three criteria. But that is some examples of it. For multinational executives, managers, you have to show that you have worked for 1 year out of the last 3 years
Okay.
as a manager or executive level position, but in a qualifying organization. So there has to be a company, say in India, a company in the US. There has to be a relationship between the two companies, either parent, subsidiary, or associate. And you should have worked as an executive or manager in the Indian organization for 1 year over the past 3 years, and you have to be able to prove it. So that is something with reference to multinational executives. So I think we've pretty much covered a question, at least to a certain extent.
Yes, yes, we did. And Neha, thank you for your question. I know this is a lot to grasp, and there's so much more under this. It's not like we covered it just on top. So I'm sure you have more questions. Please feel free to keep commenting, and you can even write to Attorney Prashanthi Reddy. You can call her on this number 212-354-1010, and you can even email Prashanthi at readyesq.com. That is her email address. And definitely go visit www.readyesq.com to get to know more about Attorney Prashanthi Reddy. So, Neha, yes, feel free to go on and ask your questions. And Bikram now is come back with another question asking, was my question answered? So, yes, we answered your question, which was, can I ask a question? And please ask your question. We are waiting for your question. So next up is Kiran. Kiran asks on YouTube, I heard USCIS is now looking at the full picture for EB-1 applications. Does this mean we need to provide more detailed documents? What areas will face closer review?
So You could look at it that way. USCIS is looking for at the full picture, but you could look at it another way, that they're willing to look at not just narrow evidentiary criteria that are set down by the regulation, but they're willing to look at the entire story. And simply because you don't meet one of the 9 criteria or 10 criteria that are set down, they're not going to say that you don't qualify for EB-1. They're going to look at the full picture. Even if you don't are not able to submit certain documents with reference to a particular evidentiary criteria, but you're able to submit other documents or related documents which are not mentioned in USCIS instructions, they're willing to look at that also. So I look at it as a positive rather than closer review. They're actually willing to widen the scope of their review. That's how I look at it.
Okay. All right. Well, I have this. Well, Bikram, I got your question. It was not showing on my stream, but I managed to get a picture of your question. And Bikram is asking, hi, I have a question. I have applied I 485. My EAD has expired, and I have applied to renew EAD, but was rejected and returned to my home address. What to do?
Well, first find out why it was rejected. I wouldn't know why it's rejected. You would have a notice which specifically states why it's rejected and overcome the defects that would have been mentioned in the notice and refile it. And if you're not
Mhm.
sure as to why it was refused even after reading the notice, then I suggest you send it to your attorney and or send it to a attorney if you don't have an attorney who practices immigration law, and have them look at it. They may have more insight into it than you do.
Okay, Bikram, thank you so much for your question, and thank you, Prashanti, for taking it up. Well, moving on, let's go on to this next one. This is from Jadav. In view of processing times, what might be the impact of the changes on the adjudication timeline of the EB-1 applications, and what measures can be employed to reduce expected delays by applicants?
I don't see any change in processing times with by including these new criteria. In fact, the processing times could be reduced because now they will not send RFEs when they encounter these issues.
Mhm.
And they will maybe send RFEs on other issues, but at least not on these issues. So, for people who are affected by, um, which may be a small percentage, but people who are affected by these particular issues will not be affected anymore. So they can expect that their cases will get processed faster because there won't be any RFEs for that particular subject.
Okay, okay. Thank you. Thank you for taking that up. And Jadav, thank you for your question. Bikram, we have answered your question. And if you have any more questions, you can keep commenting. Prashanti, now I have another anonymous member on our Facebook group asking, does I 485J approval notice has our priority date? Recently, our I 485J got approved and it shows blank in the priority date column.
It doesn't need to have your priority date because your priority date is already on the I-140
Mhm.
approval, so you can just get it from there. Doesn't matter if it doesn't have it. Sometimes I don't put it in there.
Okay. Thank you, Prashanti, for taking that up. And Bikram, sorry. Now let's go on to. I think we've covered almost all the questions I had. This is another one. This is another anonymous participant on our group. It's pretty long. I have an approved EB2 NIW from 2016. I couldn't file EB1A as I had a baby and then baby had medical needs and I couldn't go far to work. Since then, I was on dependent visa with my spouse. Through his employer, EB2, we have EAD, advanced parole. Now I'm just starting to get back into the workforce. If I were to move out of the USA and work in Europe, do I lose my parole status? Spouse would still stay in the US. Could I come back when my date became current to get a green card? Is it possible to file for EB-1 if I'm outside of the USA? If it gets approved, will I be able to recapture my 2016 priority date from EB2 NIW? And hence, there would be no waiting as for India. 2016 is current for EB1A.
So, yes, you can recapture your priority date if you file an EB-1. Yes, you can file for EB-1 while you're outside the country. As we mentioned earlier, it's a different process. You have to file an I-140 consular processing, and then your case goes to NVC, and then finally goes to the consulate. But remember, you have to meet all the requirements for an EB-1A. And the first question she asked was, or he asked was, if I were to move out of the US and work in Europe, do I lose my parole status? So you can only be on a 485 if you're maintaining your residence in the US.
Mhm.
So at least 6 months in a year, you should be living in the US. If you're not living in the US, then you should technically they will deny the 485, and you know yeah, that's not a good way of using your advance parole, because they can stop you from coming in if they see that you're actually not living in the US and you're living somewhere else. In that case, then you'd have to file, your spouse would have to file a follow to join for you, and you'd have to start consular processing case for yourself based on your spouse's case. So he'd file an I-864, I believe, uh, I-834, I-824, a follow to join application. And then you would file with NVC, as I was saying, the visa application, and then you would go to the consulate uh, when your spouse's priority date becomes current. So that would be, so you're basically processing your case through your spouse outside the country. So you can't maintain your 485 if you're not living in the US.
Okay. Thank you so much, Prashanti, for taking that up and for answering, for your advices. It was so nice. I mean, you patiently took up each of our questions and answered each of them with so much detail. So thank you so much. It was really enlightening. So far, so good. It's been great. And I'm sure folks out there really resonated with us. They have so many questions, and I think especially for Neha and also Jadav, I think they had pretty long questions that couldn't be covered all in one go. But thank you so much for all the details and for participating today, each and every one of you. Prashanti, maybe to wrap up, our episode for today, if you have anything to say on will the latest USCIS changes make EB1 harder to get? What do you have to say about that?
Um, no, I don't see it that way. They don't mean it that way. At least USCIS is trying to be more flexible with EB1 cases and open up EB1 cases to different areas. I think that's what they're trying to do, rather than the traditional areas of science, publications, research, artists. They're trying to open it up to other categories such as businessmen, uh, entrepreneurs, etc. That's by the changes that they made in September to allowing other kind of evidence to be provided to show extraordinary ability, and also the changes they've made now, show that they're trying to be more flexible and open up the EB-1 criteria to more people if possible.
Thank you so much, Prashanti, for that end note. And folks out there, please don't forget to like, share, and subscribe, especially if you resonated. And if all of you participants got your answers, leave a like and also hit that bell icon, to be updated and to be reminded whenever we have sessions like these where you can also participate. Thank you so much, Prashanti, once again. And all you folks out there also, thank you so much for joining in, for staying with us through this important discussion and conversation we had with Attorney Prashanti Reddy today. And I hope it helped you understand the impact of these USCIS updates on EB-1 eligibility. And absolutely, thank you for tuning into Immigration and Jobs Talk Show. So, and yes, like I said earlier, don't forget to Hit the bell icon so that you never miss out on these updates. And also stay connected with us. We are there on YouTube, LinkedIn, and Facebook. All our handles is Immigration and Jobs Talk Show. And until next time, this is Nipasa Pradhan signing off for now. So take care and stay tuned to Immigration and Jobs Talk Show.
Thanks, Napasa.